First and foremost, I want to give all praises, all honor, and all glory to the mighty and holy one of Israel, whose name is Yahweh, the God of Abraham, Isaac, and Jacob, by saying hallelujah. This is the chair and founder of the FFF, fighting for fatherhood. I'm an alienated father, but I'm on a mission to be reunited with my baby and to help other fathers and mothers dealing with children's services reunite with their child. We're going to be going over trust, the most important document that you have in your life. Your number one defense against the government, against government tyranny, paperwork. And I'm not talking about a gun, because that is the Second Amendment, but I'm talking about a trust, especially for fathers and mothers dealing with children's services, trying to take their assets. Make sure to put it in a trust. All right. And also, if you like what I'm doing, you can donate on PayPal, Cash App. But I have a copy of this same document in the FFF group that we have here on Facebook. So check that out as well. All the links will be below, including the link to all the websites that I'm on. Because I'm fighting. And someone's going to get their baby back from being taken by the government, being taken by the public, which by definition means government. But in this right here, having a trust or a trust document, it's pretty extensive when you want to get a good understanding of it. But this presentation right here will give you a good foundation of a trust. So you can start looking into it yourself, or you can go to our Facebook group. And soon we will be having a website up. I'm working on it right now. But go to our Facebook group, and I will make sure to have all these documents in the group for you all to get and read for yourself. But let's start talking about a trust. One thing about a trust, all your assets are protected. You go to child support court, they can't touch those assets. All right, you get a divorce, they can't touch those assets because of the nature of a trust, how the ownership is splitting up. But let's just start reading so we can get an understanding of what's going on. So, says the trust is an excellent tool to protect assets, avoid probate, increase personal privacy, and minimize income taxes. However, trusts are underused and frequently misunderstood. This is not surprising when you consider the scarcity of written material on the subject, according to a trustee's handbook by Loring. And we definitely have some good trustee handbooks. Contact me, Zadok Israel. In the late 60s, law schools set about the process of downgrading courses in the law of trust from required to elective status. Why in the 60s? It makes me think, well, is that the same time the welfare state came about? Let's continue, though. It said in the 1960s, law schools set about the process of downgrading courses in the law of trust from required to elective status, so that while almost all law schools have made courses on state regulation mandatorily, only a few continue to afford the law of trust the status it enjoyed at the turn of the century. In most law schools, trust law is now an afterthought, buried somewhere in an elective course on estate planning. So think about that right there. Even the lawyers are not trained in trust law. So if you have a good trust, the lawyers wouldn't even know how to get your assets out of the trust. They don't even understand trust. And I'm talking about not necessarily lawyers, but attorneys who try to attorn your property. And we'll get to the difference between lawyer and attorney another time. Likewise, in the preface of Income Taxes of Trust, estates, grantors, and beneficiaries. Author Jeffrey Pennell states, unfortunately, when I first recommended our curriculum committee that we add a course on this subject, there was simply no classroom text available. So that's a good thing. It's a good thing that the lawyers and attorneys don't understand trust, because when you understand trust, you can protect your assets. It's one of the most important documents. But let's continue. I'm going to start right here. There is no mystery surrounding trust. It is true that they are less known than other types of business organizations, but they are hardly uncommon. In 1993, there was approximately 1.6 million tax returns filed for partnerships, more than 2.5 million tax returns form 141 filled for trusts, and 4 million returns filed for corporations. In other words, trusts are more common than partnerships and comparable in number to corporations. Further, the audit rate of trusts is roughly 20%, that for corporations and partnerships and in individuals. So what does that mean? That means that if we have a population of 300 million here, they say about 350, but that would constitute a good 1% of the population that know about trust and that filed, or I would say filed for a trust, the taxes. Now, let's get a better understanding of trust. The fundamental idea of a trust is to divide legal title and equitable title of the trust assets. For example, suppose Mr. Smith owns and operates a business. Because he has both legal title and equitable title, he actually works the business. He hasn't leased it to anybody else. Mr. Smith alone is entitled to any benefits from the business. Likewise, Mr. Smith is solely responsible for any liabilities and taxes in his business incur with full title. He has legal and equitable title, and that's what most people have right now. Well, all of their assets, they have legal and equitable title. But as we see right here in the trust, you can have legal title and your babies have equitable title, and you can control it while it really belongs to your babies so that they cannot take the asset from you. But suppose Mr. Smith leased his business to Miss Brown. Now, while Mr. Smith still has legal title to the business, because he still owns the property, Miss Brown is operating the business under lease and therefore has equitable title. Because the title has been split, legal stays with Smith and equitable goes to Brown. So have the potential benefits and liabilities. If the business has a bad year, Mr. Smith is still guaranteed to be paid his lease money in full. But if the business prospers, Ms. Brown receives all the benefits of the profits, no matter how large. Mr. Smith will be liable to pay taxes on the income he receives from his lease. Ms. Brown will be liable to pay income taxes on any profits generated by the business. If someone falls on the business premises and breaks a hip, Ms. Brown, who has equitable title of the business itself, will be liable. Mr. Smith, with legal title, will normally escape liability. Now, let's keep going. Essentially, by dividing the full title to his business, Mr. Smith has both guaranteed himself an acceptable income and limited his potential liabilities for business operations or mistakes. Typically, trusts also divide full legal title into legal title to property and equitable title. So legal property goes to the trustees, and equitable title is owned by the beneficiaries or your sons and daughters or whoever you want to make the beneficiary of your trust. In general, the trust division of title can result in significant gains to beneficiaries and minimize liabilities for grantors. Okay, let me say this real quick for clarification purposes. We have three parties to a trust. We have the grantor, who is the maker of the trust. We have the trustee, who is the controller of the trust. And we have the beneficiaries, who ultimately own the trust at the end of the day, who own the property. So let's put it in a family trust. The elders, or let's say the grandmothers, they are the grantors or the maker of the trust. They put their property in a trust and they trust their sons and daughters, who are the trustees of the trust. So they are the ones that are controlling all of the assets. But the grandchildren are the beneficiaries, meaning at the end of the day, they're going to have the property, and the property really belongs to them. But it's being controlled by the trustees until a particular time, where then the beneficiaries will gain control. And then they will create a trust. And that is how you have generational wealth. And that's how the wealthy can continue with generational wealth, using a trust. So when they're using these words, grantor is the maker, trustee is the controller, and beneficiary is whose property it actually is. Yet, they don't have no control. Usually people use their beneficiaries to be their children. Let's continue. Typically, trust also divides full title into legal title to property owned by the trust, itself, and equitable title owned by a trust designed beneficiaries. In general, the trust division of title can result in significant gains to beneficiaries and minimize liabilities for grantors. For example, instead of leasing his business to Miss Brown, Mr. Smith might place his business in a trust, right? And designate his children as the beneficiaries. Mr. Smith could continue to manage the business as a trustee and receive a salary for his efforts, but the profits will be divided among the 3 children. Although each child might have to pay taxes on each share of the income from the trust, in a graduated income tax environment, the collective tax burden might be reduced and net income to the family increased. Okay, without a trust, Smith business generated $600,000. His corporate tax liability might be $250,000. However, if he placed his business in a trust and divided the $600,000 among the 3 children, then each child might receive $200,000 and owe $50,000 in taxes. Collectively, the 3 children would pay $150 in taxes on the same income that would cost a corporation $250. That's $100,000 net to the Smith family, and good reason to use a trust. This is one reason to use a trust. They were talking about taxes. They was talking about how Trump only paid $700 in taxes. Then come to find out he used a trust. But let's continue. Additional benefits of a trust. A trust is private. You don't have to, it's a family trust. You don't have to let nobody see your trust. We live in an information age. Information that used to be confidential and private is readily available on almost every aspect of a person's life. Privacy becomes an increasing problem. Trust traditionally has enjoyed protected status in the area of privacy. Oftentimes, trust records are difficult, if not impossible, to subpoena. So your trust, the government can't even get the documents to your trust, can't even understand your trust. It is very important. In 1995, I followed a court case in Hawaii between the IRS and the owner of a car dealership. The individual business and family financial holdings have previously been organized into a trust. And that's important to have a family trust. We have those documents as well. The trust was refusing to surrender financial records based on a precedent that trust records are private and surrendering them could compromise the trust. You don't even have to give your records to the IRS if they're in the trust. If they're in a corporation, you do. But in a trust, you don't have to give it to the IRS. thereby jeopardize the interests of the beneficiaries. So you're jeopardizing my babies by giving you, because usually the beneficiary are your babies. And you telling the court, listen, them are my baby stuff. The defense attorney had done considerable preparation and presented various court cases that substantiated the privacy of trust records. The IRS countered with arguments that in 1938, the common law had been statutized, and the cases that the defense used no longer apply because we are under admiralty law. Yeah, forget, and right here, it has a little thing about admiralty law. We're not under admiralty law. Several times complete with the gold fringe and the flag. We can talk about that another time. The judge allowed certain very limited concessions, and the IRS was allowed to examine certain non-vital trust papers. The end result was that the IRS failed to find any fraudulent intent. The judge ruled in favor of the trust privacy was maintained, and the case was dismissed. The case, then they appealed the case to the Ninth Circuit Court of Appeals, and again, privacy of the trust was upheld, court admiralty or not. So right here, the privacy of the trust was upheld. Understand that a trust is so private that the IRS can't get involved with it. They can't touch it. The government can't touch it. Let's talk about wills, and if you had a will. Wills. While better than nothing, most wills can't truly protect the surviving family members from the horrors of probate court and the confiscatory actions, and that's the word. That root word is confiscate. So taking away taxes. However, with a property design trust, I said properly, let me pronunciate my words. Probate doesn't exist. Probate is triggered by transfer of title of a decedent's assets. Decedent means somebody who's dead. Assets held in trust are not subject to probate when a trustee dies. The assets do not belong to the trustee. His position is vacated and a successor is appointed to fill it. Right here. So we see how even getting a will or having a will will not protect you from the government. The only thing that's protecting you from the government is a trust and getting a trust document. Liability. A bankruptcy case involving Arizona Governor Symington is a perfect example of a limited liability and the trust immunity from the actions of trustees. Before he became governor, he personally guaranteed a development project that went bankrupt. When he was sued, his lawyers responded that all of Symington's family's wealth was in a trust and that the trust could not be forced into honor. Forced to honor the governor's personal debts. What does that mean? That means if you get a family trust, you put your family puts the money in a trust, then none of your family members can get sued for anything. Because all their assets are in a trust, they don't own anything. The lawyers went on to say that they were dropping their defense and that no check would be written in the foreseeable future. Imagine a legal entity so strong the lawyers couldn't even bother to defend it. A properly administered trust is nearly impossible to penetrate to satisfy personal debts. The Supreme Court affirmed the liability protection of the trust. Further, the primary objective of a trust relationship is to obtain the advantages of corporations, but with the freedom from the burden, restrictions, and regulations generally imposed upon them. So what we see right there is that the governor was dead wrong, and he was dead wrong and he got sued for his assets. But because his whole family had a trust, like all the richest families in the world, they have trust. They put their assets in the trust. So he put his assets in his family's trust and he didn't own anything. So they couldn't take anything from him. And that is how we're supposed to conduct our families, contractually with a trust. That's how we keep our family together. That's how we work together as a family. But let's continue. Income tax. Income tax of a trust and potential tax saving to the creator of a trust is not a matter of opinion, but fact. As we said before, why did the media go silent when Trump gave his taxes away? Remember, they were talking about he only paid $700 in taxes. They went silent because Trump used a trust so that he only had to pay $700 being a billionaire, which is the power of a trust. Trusts are recognized by the IRS and are issued tax ID numbers. The trust files its own tax return, which is an IRS Form 1041. Any lawsuits or back taxes charged against a trust business or property would be limited to seizing only those assets contained in the trust. If the IRS tried to collect back taxes on Mr. Smith businesses, they might be able to seize the trust businesses, but couldn't seize Mr. Smith's home, car, or bank account, which are not assets of the trust. And remember, a trust is private. So if you transfer your assets before the lawyers come in, you can always move them around. They can't see them. It's private. Understand the power of a trust. For tax purposes, the IRS separates trust into three categories: simple trust, any trust where all the trust income is distributed annually; grantor trust. Since the IRS tries to define most trusts as grantor trusts, it follows that this classification is not necessarily the trust advantage to the trust advantage. And a complex trust, defined as a trust that is not a simple trust. Note that the IRS does not determine whether a trust is statutory or contractual, or impose any restrictions on who may create one. What does this mean by statutory or contractual? Contractual means you made your own trust up, which is what this article is going to ultimately let you know, that we are able to contract unlimited here and make your own trust. Do not take a statutory trust where you just sign things on paperwork and it was created by the Congress, because then they have jurisdiction over your trust. Nevertheless, it's curious that the entire IRS definition of complex trust consists of description of what they are not. Black's Law Dictionary is less mysterious and defines complex trusts as those where the trustees have complete discretion power over the administration of the trust assets. Okay. In fact, a complex trust has a great degree of flexibility and freedom from statutory encumbrance. What does this mean? This means the trustees control everything, and statutory and statutes and all that type of stuff, which is really state rules, have no bearing in a private trust. Without getting bogged down in definition, note that it was possible to have two kinds of complex trust formed under statutory law and those formed by private contract. We will see a complex trust established in contract, not statute, is the best way to form a trust. The best way to form a trust is to make your own trust. Do not use their paperwork or their statutes or how they put together their trust. Of course, you're supposed to put your trust together correctly when it's contractual, but not the way of a statute. And so we don't see the difference between statutory and contractual trust. There are basically two classes of trust. The first is a trust established in statute by a legislator. Black's Law Dictionary lists over 85 different types of statutory trust, including living trust, discretionary trust, pour over trust, etc. Statutory trusts derive their existence from Congress and can be altered, amended, or revoked by Congress. For example, living trusts at best protect the estate only up to 1.2 million. Worse, there's been an alarming trend for the past several years in which living trusts are often set aside by the court and estates probated anyway. As a result, living trust estate is subjected to ruinous legal fees and taxes. It is a matter of time before a living trust is set aside entirely. Remember, Congress created the living trust. They're statutory. What Congress creates, it can amend or revoke. So right here, we're seeing that you should not get a living trust, because then the government has control over it. The whole reason to get a trust is to take the control away from the government and keep it private. So it's not even a reason to get one of those trusts. I don't know. I mean, I guess you can get one for certain reasons, but not for the reasons that we need it, fathers. Let's go to the next right here. Okay, so in the realm right here, in the realm of statutory law, is a realm of pure liability. If you choose to put yourself into that realm with a statutory trust, you better have a good lawyer, not a good attorney, because the attorney's going to turn your stuff over. Let's continue. The second class of trust is established in contract. The very definition of a trust is a contract involving three parties. That's what a trust is. A contract involving three parties. You have the grantor, the creator of the trust. You have a trustee, the controller of the trust, and you have the beneficiaries, usually your children, whose property it actually belongs to and will go to on your death. And they enjoy the benefits of the trust. That's why they're the beneficiaries, your children. The first party, a grantor, creates a trust and typically conveys property into that trust. The second party, the trustee, administers that trust for the benefit of the third party, the beneficiary. Trusts are typically formed by a contract between the grantor and the trustees. Beneficiaries play no active role in the trust creation or administration. So yeah, it's just between basically most of the time in a family trust is between the grandparents and the children who are the trustees. The grandparents are the grantors. The legal significance of contracts was of supreme importance to the framers of the Constitution. No state shall pass any law impairing the obligation of contracts. The guaranteed right to contract is evidence of the people's sovereignty over government, in that once a lawful contract is entered into, even Congress cannot pass a subsequent law to revoke or impair an existing contract. This guarantee is far more important than most people can imagine. For example, and then right here, and we can contract, and we should contract. We should learn how to contract, learn how to do affidavits and things of that nature. For example, suppose a farmer has a contract to receive payment for the crop that he delivers to market. If the contract is not honored and he is not paid for his crops, he'll have no incentive or money to produce crops next year. Instead, he'll only produce enough to feed himself and his family. If no one could depend on contracts, there would be no incentive to produce anything. Production will halt and factories would close. There would be nothing to sell. The stores would be empty and almost all commerce would cease. This is the importance of a contract, and you can create that contract. The right to contract is crucial to the existence of free market and even personal freedom. As proof, consider those communist and socialist society whose government are able to impair the obligation of existing contracts. Although even the most representative governments preserve some measure of the right to contract, to the extent that the right is restricted, those societies are characterized by poverty and political oppression. That's why a trust is one of the very most important things that you can get as someone who is in these United States. We have a right to privacy. We have a right to contract. These socialists and communist states don't have that right. That will make us important. And makes those laws important to us. The United States Supreme Court affirms the right to enter into a contractual relationship. The contract trust relationship is based upon the common law and is not subject to legislative restrictions, as are corporations and other organizations created by legislative authority. If Congress didn't create a contract, it can't lawfully alter, amend, or revoke it. Nevertheless, can Congress pass laws? No, we're not going to deal with all that. They can. Okay. See, when creating a trust, remember that since a trust is a contract, it's private, which can be freely entered into, there is little or no need for statutory trust of any kind. As you'll see, contractual trusts offer far more advantages than statutory trust. Therefore, the subject of trust can be hugely simplified by ignoring statutory trust and focusing entirely on contractual trust. All right. Grantors. A trust begins with the grantor, who typically not only designs and creates the trust, on paper, but also endows it with some of its valuable assets, land, businesses, money. So the grantor is the one who puts the property into the trust. Once a trust is created and endowed with assets, the grantor must disassociate himself from the management of the trust and the assets he placed in the trust, or the IRS will cheerfully classify his creation as a grantor trust and tax him accordingly. Trust can be revocable or irrevocable. If a trust is revocable, the grantor has the legal power to take back whatsoever property he puts in the trust. This may seem like a safety feature in the event that a person changes his mind, but in reality, it is a gaping hole in the trust armor. In the eyes of the court and IRS, if the trust is revocable, the grantor technically still owns the property he placed in the trust. If he owns it, he can be taxed on it or even have it taken away from him in a judgment. So what does that mean? That means the grantor who puts the stuff into it, if you have a revocable trust, that means the grantor can bring all his property back to him and be sued for it. But if it's irrevocable, what he put in there, he can never get again. And that's what protects from lawsuits. Because if somebody can sue you as a grantor and you have to get all your stuff back, then they can. But if it's irrevocable, you would put your stuff in that trust, you can't get it back. All that stuff belongs to the trust. You can't be sued for it. And that's why it's better to get an irrevocable trust. Therefore, to minimize IRS intrusion, it is vital that trust be irrevocable. The grantor retains no residual or revisionary power over the trust, and therefore cannot tell the trustees what to do or take back his property. The idea of permanently surrendering all control over your property to the management of others is a scary concept for some people, but is the key principle for intentional attribute of the term trust. That's why it's a family trust, because you trust your family with these assets. All right. And if it's an irrevocable trust, you put your assets in the trust and your family controls the assets. You trust them to control it, and therefore you don't own it. You have no liability. You can't be sued for it, but you still have it. It's a simple matter to make a trust irrevocable. The grantor simply declares it's irrevocable in the trust indenture. And there's two different documents. When we talk about the trust indenture, we're talking about the thick layer of papers dealing with the trust. It may be not that thick, but when we talk about the trust certificate, it's one page that may have the EIN of the trust and have a little bit of information, and you put that in the county clerk to let them know for evidence of having a trust. Okay. Let me start over. And this is a simple matter to make a trust irrevocable. The grantor simply declares it's irrevocable in the trust indenture, the document which created the trust. And it is legally so because when the grantor creates a trust, he is literally creating law. The people making law, what a radical concept, exactly what's meant by holding we the people as sovereign over our government. If a trust finds itself in court, for whatever reason, the judge must use the trust indenture as the guide. So you literally make how your trust is to be treated and how people will violate it and how people will do right by your trust when it goes into a law, into a court of equity. When assets are conveyed irrevocably into the trust, the tax liability of the assets no longer attached to the grantor, while the tax deductions for individuals are disappearing one by one. Deductions for trust have remained almost perfectly preserved. Therefore, why do so many competent professionals disagree on this point? is because of the lack of familiarity with trust and their potential. I repeat, principles of law pertaining to trust are not complicated. They are just not widely known. Details pertaining to taxation of trust are available from a variety of reliable sources. One of the sources I reference frequently is Practitioner's Desk Book. But right here, what is it saying? It's saying that only the rich. Now, let me not say that, not only the rich. But as we read earlier in this document, in law schools in the 60s, they stopped doing classes on the trust. But a trust protects you from paying many different things. As you see, Trump only paid $700 on his taxes. What does that mean? That means he used a trust, a family trust. But let's continue. A trustee. There's a great deal of difference between being a grantor who places the property in a trust and a trustee who manages the assets for the trust. And remember the story of the Arab soccer player who had $70 million and his wife had $2 million. And when his wife divorced him after 3 years, she thought she was getting his money, but his money was in a trust. So since his money was in a trust and the beneficiary was his mother, basically everything was in his mother's name. Some grantors go to so he was a trustee of his thing. So what happened was, because he was a trustee, he manages the property. He was using all of the assets that he put in the trust, to the point where his wife thought that he still owned all this stuff. But no, babes, he didn't own all of it. He was just a trustee to all of it. Let's continue about it. Some grantors go to great pains to create a trust and still retain control over the assets by making themselves managers or protectors. They do this because they don't understand the concept of trusteeship or irrevocability. Assets conveyed irrevocably are transferred into the trust just as they are sold, so long as the grant is irrevocable. The seller or grantor may make himself sole trustee or one of the several trustees. Therefore, the grantor may administer the trust as trustee without retaining any residual power or interest. The court agrees. By declaration of trust, the legal title, possession, and control of the trust estate pass irrevocably from the grantor as an individual to himself as a trustee. The effect is no different than if the trustee had been another person. So we see you can be a grantor and a trustee of a trust. If a trustee understands his role and administers the assets for the benefits of the beneficiaries, there is no danger of the trust failing for that reason. Trustees in a property created complex trust have complete discretion and broad powers over the administration of a trust and its assets. Though trustees must follow the trust indenture as a general guide, no one can tell a trustee what to do. Trustees may even amend and add to the trust indenture. The courts have ruled that in order for a contract trust to fail, the trustees must willingly and knowingly commit fraud. A trustee will not cause a trust to fail because he makes an administrative error. Let me see. The court recognized that trustee's job is not to be a lawyer, but a custodian or steward over the assets. Historically, there is a great deal of leeway given to trusts in the administration of their duties. Fraudulent misintent must be proven. Intent is much harder to be proven than a simple mistake because of oversight. Eventually, if a trustee makes a mistake, he must correct it, and have done so is personally immune from any civil or criminal liability. Liability cannot be assessed to a trust because of the actions of the trustee. Similarly, a trustee is not liable for the debts of the trust. So I understand, and as we go forward, we all will have an understanding of a trust. This is just going over today. when you get deeper into understanding these different words, like administer means to control it, or administer means to regulate it, and a trustee, and what is a beneficiary, and what's liabilities and what is debt. You have I hope I'm not talking over people's head. However, a problem will arise if a grantor also makes himself both a trustee and a beneficiary of a trust. It is hard and fast rule of trust that trustees cannot also be beneficiaries. All right, you cannot be a trustee and a beneficiary of a trust. You can be a grantor and a trustee, but you cannot be a trustee and a beneficiary. However, additional assets like a house or car can be purchased by the trust and conveyed into the trust as trust property. This can be accomplished with no tax liability to the former grantor, who resides in the trust house or drives the trust car. Although there is some dispute among legal and accounting professionals, the trustee may occupy the house or drive the car at no charge or tax liability to himself. So right here, what is that saying? When that Arab soccer player got divorced and they said he put everything in his mother's name, while he still enjoyed his car, he still enjoyed his house. Being a trustee, he still enjoyed everything, and his wife thought that he still owned everything. But guess what? He had it in a trust. So it wasn't his, it was a trust, and it actually belonged to his beneficiaries because he split title in a trust from legal and equitable title. But let's continue. There are numerous letters ruling involving the IRS where the person occupying the house is not assessed income, and the entity that owns the house is allowed the deduction. The pivotal point is contract. The trustee or employee may occupy the residence if it is a condition of employment and stipulated in the employment contract. The same rules apply with respect to a car. In the absence of a contract, the point is less defensible. So you can just contract yourself as taking care of the house that your beneficiary owns. Let's say you make the beneficiary your babies. You put the house in your trust. You contract yourself out to take care of that house, and you can enjoy all the assets until your baby's old enough to get what he deserves as the beneficiary. Trusts are powerful tools for estate planning and administering assets. By entering into a complex, irrevocable trust, you can alleviate your family and business financial dealings to a higher plane and be ruled under a non-statutory set of laws. So a trust helps you rule yourself and not the government ruling you. The benefits of a trust are available to anyone who freely elects to use them. A degree of privacy and protection from liability can be achieved that is otherwise unavailable. Probate can be totally avoided, income taxes reduced, and personal liability virtually eliminated. It is reasonable and prudent for a person to reorganize his affairs so that he may enjoy better privacy, protection, and improved tax position. The courts have ruled specifically that a person is not more or less patriotic because of the amount of taxes he may or may not pay. And additionally, a person may choose or organize his affairs whether or not the resulting benefits or tax savings are incidental or by design. Many of the benefits of trust can be achieved using corporations and other statutory entities. However, the contract-based complex irrevocable trust is clearly protected by the courts for various reasons. Even given a choice, I would rather have the protection of the courts than to have to depend on my wits or luck to keep me out of harm's way. Okay. All right. And this is by Glenn Holiday. As I said before, I will have this document in Fighting for Fatherhood on Facebook. Once again, this is the chair of Fighting for Fatherhood. I understand it's 45 minutes. I understand it was extensive. I understand it's a little complex, but it'll get easier once we go through it. We all need this. We talk about generational wealth, especially in the Black community. This is how you grow generational wealth, by having a business trust. As we see, the governor of Arkansas had a family trust. These things keep families together. They help manage the affairs and the assets of the family and do it in an equitable way so that you avoid the court. Because when the court gets involved, you get a divorce or something happens, then they are very harsh. This is why you get a trust. And remember, I'm an alienated father on a mission. I haven't seen my baby in about 2.5 years. I will be reunited with my child. And I'm going to help other fathers do the same. Help me. I'm working now. I'm working for you all. If you want to donate so that I can have more time to work on this to help you all, I have the links down below. You want a copy of this document? Just it's in the comment section. And I have a link to all of the platform that we putting this different information on. But I want to say, once again, I want to give all praises, all honor, and all glory to the Holy One of Israel, who has keeping me alive until this day. The God of Abraham, Isaac, and Jacob. May he continue to have mercy on me. And all of you brothers, pray for me. All the sisters dealing with children's services, if you need help, go to Fighting for Fatherhood. Contact me. Let me know children's services have taken your child. I love you, and I will help you. All praise to Yahweh.